Hey, yes, hello. Uh, Good afternoon. A good afternoon to all of us that are here. We welcome you. My name is Rebecca, and I work with MABS, as you can see. We usually organize member sensitization sessions for our members to equip them with tools on how to secure their dignified retirement. Without further ado, we're going to kick off the program. We're going to start with an opening prayer from our very own trustee, Mr. Joseph Ikarokok.
Thank you, Rebecca. A very good afternoon to all members, both physical and online. I would like to stand before you and give a word of opening prayer. This afternoon, loving Father, we thank you for this moment. We thank you for this time. We thank you for the gift of life. Thank you for bringing us both physically and online. Loving Father, as we are preparing to receive a very special message from Mr. Isaac Bakayana on the issues pertaining our future in terms of finances, that's securing our legacy. Loving Father, we pray that you touch him and give him all the knowledge that is going to be imparted to the members so that it can be useful to us now and even at our retirement. And Father, we pray that you really touch all those who are on the way, who are coming, and also don't interfere with the internet, those who are online, so that they be on up to the last minute. And Father, we pray you continue blessing our scheme to see that it grows to greater heights. All this I've prayed in Jesus' name. Thank you.
Thank you very much, Mr. Ikarokok. Today's session is on securing your legacy, legal foundations for financial security. But before we do that, we're going to have some opening remarks from our Secretary, Board of Trustees, MABS. We welcome you, CPA Francesca Angida Mujema.
Thank you very much, Rebecca, for welcoming me here. Dear members, you're most welcome. I'd like to recognize all our stakeholders present, the trustees, members of the university management, present both online and physical, staff association executives, all members of the scheme, and the secretariat members present. I can see the dear PPO Susan is around. Thank you. Rebecca is here with us, and others also outside here serving us. Welcome to today's sensitization session on securing your legacy, which is the legal foundations for financial serenity. But I'd like, first of all, to highlight on a few developments in the scheme before I go any further. Recently, we had elections in December when the term of the MWASA trustee ended. Our trustee member, Professor Godwin Kakuba, his term ended in December, and we had an onboarding of a new trustee, Dr. Michael Chizito, here present with us. Welcome you, Dr. Chizito. At opportune time, you'll hear from him when he comes to have his remarks to you members. Then also there was a returning of the two trustees, Mr. Joseph Ikalkok and myself, Angida Francesca Mujema, who serves now as the board secretary. Then also Dr. Chizito, whom I already mentioned, who serves on the board as the secretary, rather as the chairperson. Sorry about that. Those are the recent developments. We can see them on the pictorial bit of it. And we would really want to appreciate you for entrusting us, and we are humbled to serve you. We thank you, all our members, for entrusting us the opportunity to serve you. And now, recently, we also held a seminar workshop on to commemorate on Women's Day celebrations on the 6th March, which was talking about accelerating action in retirement planning. The objective was to empower female members who were approaching their retirement. The members who attended were female member trustee members, those who were above 50 years, as I mentioned, the trustees who were also female, then secretariat staff, annuitants, UBRA, our regulator, Stanbic Bank, specifically SBG Securities. And we had a wonderful session because we were able to empower women and they were all happy to participate. Because our key discussion points were proactive financial strategies, reviewing savings and investments, diversifying income, health and care plans. So we had a social and holistic preparation for social capital and mental adjustment, whereby ladies were informed that it's not only about finances and everything, but also that they needed social capital when they retire, when we retire as ladies who are approaching our retirement. Then also talked about the role of annuities and debt repayment, institutional support and accountability, especially by UBRA, who is our oversight body, then SBG Securities Resources. We thank all the members who participated. You can see them highlighted there in the pictorial bit. Members who came were able, we had a turn up, a big turn up for ladies that managed to make it. And then our secretariat, we are forever indebted to you because you always prepare for us well, and it was a success. Yeah. And our outgoing chair, Dr. Elizabeth, was forefront of this organization. We appreciate you, Doctor, wherever you are. And then you've all seen the pictorial bit of it. I also would like to talk about the topic today, which Rebecca mentioned, because we have a powerful speaker who is going to talk to us. Our topic being securing your legacy, legal foundations for financial serenity. And in our pursuit of success, I believe that building careers, nurturing families, and growing businesses is easy to focus on now and forget about the lasting impact of our financial choices. But true financial peace isn't just about what. Sorry about that. Pardon me. It's not just about what we are accumulating during our lifetime. It's not about the money we make here and then, but it's about how we protect, preserve, and pass it on to our other people who come after us. The legacy we leave is not just about wealth. It's about values, the vision, and the responsibility. It is the mark we leave behind and the assurance that what we have built will continue to serve, to support, and sustain the people and the causes we care about. We should be cognizant of that. Also, that's where the law comes in. For that matter, that's where we really need the law. That's where the law comes in, and not as a formality, but as a foundation. The wills we make, the trust, the powers of attorney, the estate planning, these are not tools for the wealth alone. They are tools for the wise like us, the MABS people, and the members. They allow us to make control of the future to avoid unnecessary conflict among the family members, to ensure that our intentions are honored with clarity and dignity. Therefore, today, as we explore this vital topic, I encourage each one of us to think not just about the financial security, but about financial serenity. The peace of knowing that what matters most to us is protected by a solid legal foundation. Therefore, I implore us that let's learn, we engage, but most importantly, we should act. We don't just keep coming here to learn about those things and we leave them here. So, who is our facilitator today? I'm sure you are all eager and ready to hear from our facilitator. Mr. Isaac Bakayana is an advocate of the High Court of Uganda. He practices law with Acadia advocates, and he lectures estate planning, legal methods, introducing law and equity, and trust at the School of Law of Makerere University. This he has done since 2006. He attended Makerere University, where he did his Bachelor's of Laws, Law Development Center diploma, in legal practice, and the University of Warwick, where he did his Master's of Law in Development. He is a member of Uganda Law Society, East African Law Society, and International Bar Association. He largely views himself as a practitioner of law in the space of problem solving. For that matter, I'm sure we all shall all live here when all our problems are solved. Mr. Isaac Bakayana, you are most welcome. Let's give him a loud of applause as he comes to talk to us.
Good afternoon, ladies and gentlemen. I'm Isaac Bakayana, and I'm happy to be here. I was contacted probably a week or so ago by one of my colleagues in the office, and initially they asked me whether I still teach estate planning. And I said, yes, I have been teaching estate planning at the university for probably 15 years. And it's a discussion that I like to engage in. So he then said, well, you need to be party to the discussion. Initially, when I was invited, I was told, you're going to talk about wills. I said, well, wills is a succession. It's not exactly estate planning. But later, when I got the topic, I realized that it was much more than wills. So this afternoon, I propose that we have a discussion on securing our legacy, the legal foundations for financial serenity. Because I go to court very often, I would say almost on a daily basis, I have come to see certain things with the law, but also with what I call the practice. That there are things that are within the law, there are things that we do, there are things that we all know, but yet we continue going to courts of law every day. And the quarrels are not usually very far. So I have started the discussion to understand what a legacy is. And a legacy for us, for the lawyers, we can make it look like a material thing, that property, that gift of personal property that you want to pass on. Usually we shall say that you're passing it on Most of us think on death, but as we are going to see shortly, it can also be before death. And the other definition is a gift of money or other purely personal property. Will I retire or die? Of course, definitely. I know when we discuss death, it brings sadness, it brings fear. Some people don't want to talk about it, and they say nze nkizayo. But chizayo in its is not enough, because whether you kuzayo the death or not, it is coming one way or the other. So you need to prepare. When you're born, then the next thing that is going to happen is certainly death. If death is going to come, then we need to begin planning for it. We need to begin thinking about it. What should we do? The day I joined Makerere University, the person who gave me the talk before I joined the university, when I got my letter of employment, they told me that I should also type my termination letter, my resignation. They told me that the day you joined the university, on the 1st of January 2006, this person told me, type your termination letter as well. Let them always be together, because you're going to leave the university, whether you like it or not. So if we know we've been born, then the next thing that is going to happen is death. As we acquire the property, therefore, it is good for us to plan for this certain thing, which is coming. We know it is coming. So if we know it is coming, the moment I've been born, the thing is coming, then the better thing to do, I'm proposing here, is to develop a plan for the future. Have it, think about it, nurture it, grow it, and then try to put it into play. Because having a will, having a trust, knowing about retirement does not make me get closer to the retirement age. Does not make it faster for me to get there. Death is coming. By having a will or having a trust or distributing your property when you're still alive, as we shall see, does not mean that death has come to you faster than it should. It's going to come at its time anyway. So I ask the question then, is planning necessary? And my answer is, of course, definitely. Because as I go to court every day, probably some of you have heard. You've been there, probably. You have friends who have been there. But the last thing you want to be is the High Court Family Division. Because every day you go there. And it's not just, people think that you'll find there younger people. No. All ages. 70, 50, 30, even kids, babies, they're being carried to the family division because they want the judge to see this baby who's being deprived of money because someone did not plan. So when you go there, do you only find Muslims there? They're thinking that because these Muslims marry so many times, they are the ones who are, no, everybody. Muslims, Anglicans, Catholics, you're there. So when you don't plan, today, your family is going to be in that division and they're going to plan. True. Is it necessary? I'm saying yes, because you manage your family's expectations. Some of your children, some of your brothers, some of your sisters, some of your relatives have given themselves property in your property. When they look at your property, when they look at your money, when they look at the money in MABs, when you tell them there's 500 million shillings, they begin to share it without your knowledge. They get an entitlement in your property without your knowledge. So you must plan, because you need to manage people's expectations. People who don't deserve anything, you should break their hearts in your documents. Don't give them anything. People who deserve, plan for them and have a document that lays out that plan. Ladies and gentlemen, planning is also good for taxes. When we see the other side of it, estate planning in the realm of trusts, there's also tax planning there. Preserve your wealth. You have worked so hard for the last 50 years you're working. You don't want it to be squandered because you didn't write simple documents. So you need also to preserve your wealth, and then you pass it on. I've called it the cow. You've worked so hard to get the cow, so fight so hard to preserve this cow. But importantly, also for the peace of your own mind. There are many examples when you look at newspapers for being taken to hospitals, to banks, bank when they are on their hospital bed. Because they didn't plan, they didn't think they would fall sick. Oh yes, you're going to fall sick. We are humans. The body gets tired, the organs get tired, they give way. So you begin to fall sick, and because you didn't plan, when you get to hospital and they need 100 million, they need 50 million, they need 20 million, the bank says, unless we have seen Bakayana here, we're not giving him money. When they bring me on the hospital bed, then I have to go on the till then I begin signing, and all of us, these days someone takes a picture casually and you're on Twitter, you're on X, in a snap, you're in America, you're in England. I say, but this person has been a lecturer at Makerere University for 40 years. Okay. Because you did not plan for that incident. And these things are coming. I always recommend that when you plan today, actually you're late yesterday. You need to have, when you join the university, when you begin working, you make plans of how you're going to save your money, how you're going to invest your money, how you're going to grow your money. Then you stop there. You don't think that you're going to die, you're going to retire. You plan for building, getting the land, building the house, building the business, and then you stop there. When you get the business, when you get the home, when you get the car, when you have the savings, you stop there. And you forget you're going to retire. And you forget you're going to die. You forget that in retirement you're going to fall sick. You forget that you will need the money. So when do you plan? You plan, you begin the plan today. People who are going to benefit from you are known. We know them. There's no pretense. So when you begin to plan, you plan with them immediately. I always say you involve the family. You teach them and they teach you back. Then they graduate. Then they know there will not be a quarrel when you're so sick to talk, when you're so sick to write, when you can't go to the bank, because you've been taking them through the school of life with you. You've been learning from one another and they graduated. You've been growing together. Everyone is learning what I can do and what I can do, whom we can trust with the account, whom we cannot trust. You can even share the ATM card and you have no problem because you planned it. So you don't need to go to a bank on your sick bed to draw money because you didn't plan earlier. You instill ethos, and ladies and gentlemen, what COVID taught us is not to begin planning when COVID has attacked you and you can't breathe anymore. You can't do anything. You're sick. Because you're sick, there's nothing you can do. You need medical help. But you begin planning when you realize you can no longer breathe. So don't plan at that point. This is the time, if you haven't planned already, plan. Retirement. We all know the retirement age. I always laugh at people who celebrate birthdays, and I say every birthday that you celebrate draws you near to retirement and death. Every birthday. Are you 50? You're growing closer. You're not growing younger. Every birthday you celebrate, you're growing nearer. So it means that because of those birthdays that you celebrate, your bank sends you messages on your birthday. At least mine does. And then it pops, and then they send me good words. I have to ask myself, if I'm drawing closer to retirement, what am I doing about it? Have I planned? As we all know that the things that we enjoy today don't stop when you retire. They continue. Actually, if anything, when you're growing older, the body also begins to need more help. You fall sick more often. Even a cold can disturb you, yet it used not to. So you probably need more medical attention at retirement, because as you draw closer, the bones become weaker, everything is growing. It's not growing stronger. your retirement benefits are triggered by particular requirements. There's a form that I filled when I joined this university. I remember it, and it says, where do you want to put your benefits? You throw a name there casually. Quickly, you return the form there, then you forget about the form. Then you work in the university for 20 years. You never look at the form again. When there are requirements, when the university says there are requirements that you must fulfill, we need you to update your form. You never go there. You see the email, you read it, you understand it, you ignore it. They send a reminder, and you do nothing. Then the day that you retire or you die, you only realize that this form has information that you yourself can't identify. So you need to communicate with your employer. You need to communicate with MAPS. You need to update them. Because as we're going to see shortly, it is important. If you're entering retirement, and I'm now speaking as a practitioner, you get all your savings and then you start the business of importing and selling maize. You've never done it before. You don't know the vagaries of the market. You don't know whom to, and then you get all your money and then you pour it in maize. You're going to defeat the purpose of a pension. You're going to defeat the purpose of Social Security. Because the idea is to look after you after you have left. Only for you to get into business that you have never. You think about, you see successful people, you see farmers, and you begin to say, these ones, I need to join the maize business immediately. Only to get into the market and they reject you. Then you lose the money. What I have seen as a practitioner is that when they know that you have money, we have, ladies and gentlemen, we have fraudsters in Uganda. There are so many, and somehow they know that you have money. Then they begin selling you all the ideas that at that point you think make sense, but actually to the rest of us, they don't. Because you've been a lecturer, you've been here for 40 years, you've never done any business. How is someone giving you an idea at 65 and you're accepting the idea and you get all your 600 million and you put it in maize? You don't know the change. You don't know anything. So in retirement, you're going to be taken advantage of. And I'm speaking as a practitioner again, because I see it. I see the quarrel. I deal with the end. I rarely deal with the beginning. People come to law firms when they have problems. And we see these things always. So I have the benefit of looking at these things and I'm asking him, but how did you do this? What are the tools? What are the possibilities? The will, we all know what it is. The trust, we've heard of it. Maybe not so sure about it. The company, yes, the company. The business. And the gift in life. The two, trusts and the company, I usually say they are very good for business. If you're engaging in business, those are the two possibilities that you can think of. If you're thinking of death only, then the will. And the last one, a gift in life. I'll try to look at each one of them. The will document anything. For law, in a will, we only need it to be written and attested to by two people, at least. That is what the law says. The law does not tell us what should be in the will. It only says a will must be signed in writing, signed by the maker, and two attesting witnesses. An attesting witness, ladies and gentlemen, is a person who sees you signing the will, not a witness. I have not said a witness. I have said an attesting witness. An attesting witness is important because he's the one that proves your will. He's that one person we call to court and we ask, is this the will of the deceased? We need only one person. And that person comes and says, yes, I saw him sign the will. I can confirm that that is his signature. That is his will. So it means, therefore, that you don't sign before the maker signs. The maker signs the will Then you see him signing, and then you also confirm, because we shall need you. And I've said there, the will contains anything you want. Write a novel, write a page, write 30 pages. It's your will. Write whatever. Write your history. Write the history of your clan. The Lord doesn't tell us what you write. Write anything you want. Ladies and gentlemen, write all your children. Men, hiding children. These are your children. I hear people calling them illegitimate children. What does that mean exactly? They are your children. Down there, you've hidden them in the village, down. They are your, because in law, they have an entitlement to your property. They have an entitlement. So you can have 10 and you hide them in Masaka, in Jinja, in Luka, in where then in your will you put only the 2. We all know those 10 are going to come to court and they are going to cause trouble to the other 2. You won't believe it. So write your will and put everything there. All children are your children. It talks about storage of wills, whatever you want to talk about, your debtors, your creditors, how you want to pay them. When you change your mind, the law allows you to change your will. You can change your will as many times as you want, but don't have 2 which are together. You don't revoke one. You don't remove one completely. You have another one, then you have another one, then all of them, you give one to Bakayana, the lawyer, then you give one to your friend, then you give, and all of them are saying different things. Have one. When you make another one, say the other one is no longer binding. I have now this one. You can change a will, review, actually, practice. They say that when you get to 50 and above, look at your will regularly. The law doesn't define, the law doesn't require you to look at it regularly, but in practice, we recommend have a look at it regularly. Every 3 years, look at it. Is it still making sense? Are the things that you want still the same? You can change your mind about certain things. Have some children annoyed you? You want to remove an ad, and it's okay. It's your will. Ladies and gentlemen, it is your property. It is your property. The Constitution of the Republic of Uganda gives you the right to your property. And it says, use your property as you want. You can give it. We see white people giving property to churches and cats and dogs. That's not real. If you have a dog you love, please give it. It's your property. Deal with it in the manner that you want, because it's your property. So you can change it as often as you want. One thing that I will talk about here are executors of the will. These are very important people, because these executors, ladies and gentlemen, one, they are not the owners of the property. In Uganda, commonly, executors, we call them administrators, have now become the owners of property. We go to courts and you find administrators say, oh no, that is not your property. You are, let me use maybe management language. You're a manager. You're a CEO. You have been appointed, and the role of the executor, ladies and gentlemen, is to distribute property. Nothing more. An executor, as we shall see, is different from trustees. Trustees have a wider role. But an executor in law, their role is to distribute, and the law gives us, they have changed the law now, 6 months, to distribute quickly, and you close the estate. If you find someone is executing an estate of a person who died in 2008, what are you doing? It's nothing for you to do. Your role is to get the property and then pass it on to the beneficiary. So, nothing more. Distribute the property. And they are the ones who have the power over the property. They distribute it and then make their inventory to court. And then they say in the inventory, I received 10 properties. This is how I received it. I distributed it. I got money from MABs. This is how I was taught to distribute it. And this is how I distributed it. They make the report. The estate is closed. The business is done. My view for wills and the things I say to avoid. Some things I've seen in law, some things I've seen in practice. I'll share both sides. The first one, I think that for me, from going to court every day, I have come to the realization that We make wills to avoid, reduce conflict. I have seen conflict where there's a will. I've also seen conflicts where there are no wills. But I will tell you that the conflict where there's a will is lesser. The conflict where there is no will is, unless you're lucky, is a much bigger conflict. So the idea for me is you really need a will to reduce conflict. Deal with your property is your property. But the things I always see that bring problems, introduction of new spouses. You have your spouse, you keep quiet for a lifetime. When you die and we open the will, we find another wife. We've never seen him, never heard of him, nothing. New children, you have 6 more. And then you give them the most. You say, these ones are still young. I have given them 80% of problems are coming. For some reason, people are angry with their spouses and they never tell them. When you open the will, you find the direction. Get out of my house immediately. It is now illegal. Don't attempt to evict spouses on your death. Tell them when you're still alive, I don't want you, please go. And we see. But you keep quiet, then in the will you say things which are outrageous. Get out of my house. No one is getting out of your house. We're going to court. Some children annoy you so much that you don't want to give them. You get so angry, then you unbath them, then you don't give them. You're joking. Be fair. Even when they have annoyed you, forgive. If God is forgiving us every day, God is forgiving us every day. We trespass, we sin, we do what? He forgives you when you're 8 years, when you're 30, when you're 50. For you, you're wronged once in a lifetime and you go to death with your anger. When you don't give, what I'm saying here, be fair. The Lord does not tell us how to deal with our property. It's our property. It's your property. Deal with it as you desire. But the things I have seen that bring a lot of problems is where you have 10 children and you get these 2 children and then you say, these ones I'm not giving anything, and then you list the sins they committed against you. You have another thing coming. Do not be unreasonable. Common cause of problems. You are unreasonable. Some of us are unreasonable. We give directions that are unreasonable, that you know no one will do. You even fear to tell them when you are alive. You want to communicate these things in death. No one is going to do them. I recommend not to write a will when death has approached. Usually you see when people are in hospitals and people are bringing papers and pen and saying, you need to write. It's very wrong. Because you're not thinking straight, you're under the influence of the disease. You're going to make mistakes. Writing wills under the influence of influencers. You've seen these ones on X. People who influence you. We have them in our lives. We get them, and then you begin to write a will when someone is influencing you, and then they bias you. When they bias you, make mistakes. When you make mistakes, the lawyers are available. We are so many. Writing vague wills. Go to lawyers. Don't write wills that are not saying anything. You say something, but no one can understand what you're saying. You have lawyers. You let them read through. Let them advise you. Take some advice. The biggest one I have seen, you write wills. Then on the side here, when you're having lunch, when you're having breakfast, when you're moving with your children, you begin telling them other things. By the way, for you, I gave you my MAPS money. I gave you 100 million of it. When you know in the will you actually did not. I gave you that car. This car is yours. When you know that in the will you did not. Now, in life, you're communicating something else. In the will, you're saying something else. Then chaos breaks out. Because when they read the will, the money which you're entitled to from your retirement scheme, it's given to somebody else. Then the person you gave it to in life, they'll begin saying, chairman, they were available when this person was giving me the property. So what is the will saying? Keep quiet. Don't talk about your will. Don't talk about giving. If you decided to give by will, let the will speak for you when you die. Don't speak when you're alive then. And then you begin giving positions that are contradictory. ignoring outside children. I've already emphasized that these are your children. They have an entitlement in your estate. If you don't give them, I can assure you courts will, because they are your children. They're entitled. So include them, brave. You had them, write them in the will. I have 15 children, and you name them and you give them. A will takes effect on death. It is your constitution. When you die, you speak through the will. It guides the executor, because the executor just opens the will and begins reading. You, this one. You, this one. You, that one. From experience, it is the shortest way to administer your estate. And I've talked about executors, because when you die, the executors of your will take your will to court to prove it. They need it. And then it is the basis on which court will give them authority to deal with your property. At this point, we no longer have, the law has been changing, but now we no longer pay stamp duty on transferring property of deceased people from the deceased to the executor, and then finally to the beneficiary. When the executors get the probate, they will transfer it to their names and then transfer it ultimately to the beneficiary. The money, there is some money that is paid, but it is minimum, 15,000, 20,000. It's not money that can worry the executors. The will manages expectations, and it eases the work of executors. In Uganda, commonly we see executors substituting their desires for the desires of the deceased. It is not allowed. It's wrong. The executor's role is to implement. So one of the avenues as you go into retirement is to think of a will. Do I have a will today? And I have said, a will is not sophisticated. It is what you want, where you want to be buried. You can tell us a history, you can tell us a property, you can tell us how we want to do it. You can tell us everything. It's your will. The only thing, have it signed, have it attested. It is a good document. A trust, and standing here in this facilitated by MABS, a trust is basically a relationship of property. It's about property. So MABS is managing property, money. The beauty with a trust is that for it even works in life. You do things which you want when you're still alive. It can also take effect on death, depending on what you want. It's your property, it's your document. If you want to use it, you know that it has so many, it can protect beneficiaries against themselves. It can delay a benefit to a beneficiary. It can split a property. One beneficiary can take this building and another beneficiary can take the income from this building. It can arm trustees with discretion when to give, how much to give, out of what to give. It's a very good flexible tool. And also, importantly, it can take effect in your lifetime. You can use it when you're still alive. Then you distribute and all the quarrels come to you. And then you ask the children who are challenging you what their contribution is in that property they're quarreling over. You handle them at that point. Its creation is one-sided. I always say a trust is more flexible than a contract, because a contract, you negotiate it. A trust, you get a piece of paper, you write what you want. It's like a will. Because a trust is based on trust, I always say appoint persons whose judgment you trust, because they're managing your property. And that property, ladies and gentlemen, we transfer it to them. We arm them, because the essentials of a trust is that we must arm. I'm a beneficiary of MABS, but the power is with the trustees. They sign. When they sign, money moves. When they don't sign, money can never move. So that's why I say a trust is seated on trust. Don't appoint people whose judgment you don't trust. In this deed, you define their powers, you define their duties, you define what they can do and what they can't do. In the deed, everything you want, you write where they can invest, where they should not invest, what they should give, how they should delay, etc. If you don't, then in the law, those powers and duties are there. Ladies and gentlemen, if a trust is engaged in business, of course, it pays taxes. There's a similarity between an executor and a trustee, but they're not the same. Executors, we found them in the wills. Trustees are in this business of trusts. They can be appointed by will, they can be appointed by a deed. But I emphasize again, if you're appointing a trustee is a person whose judgment you trust 100%. I think I should also say the same for executors. The people you appoint to implement your will are people whom you must trust, because the law is going to arm them with your property. So you must be able to trust them. From experience, again, I say appoint people who are willing to invest time in your affairs. Don't appoint people who don't have time, because it requires time. It requires a lot of sitting, a lot of signing, a lot of movement, a lot of work. So in addition, there must be people who you trust. A trustee can be anybody. If we remove the other classes, you remove classes, people with mentoring capacities. If we remove those ones, the rest you can appoint. A gift in life. If you don't want to write a will, if you don't want to also write a trust, you can just make a gift in life. The law does not refuse it. The principle I mentioned earlier is that the law has said that the property is yours, and you deal with it in the manner that you deem fit. How you want to deal. You can dispose of it by will. You can dispose of it by a trust, but you can also give it away in life. What we call a gift inter vivos, a gift when you're still living, and the law does not refuse it. But we always say, put it in writing, and if possible, transfer the property immediately in your lifetime. But you remove quarrels. You're not going to quarrel when you're dead. If you die without a will, it's even worse. So if you want to distribute, if you can distribute it, and then transfer it, and then you give it away. You can even give it with conditions. I'm giving you my house, but I first die for you to take it over. It's your house. You determine how it's going to be given away. Once you give it away, and what I have seen commonly is that when we give away this property, at times we go back in our wills and then we will it again. No, you've given it away in your lifetime. It is no longer your property. Please don't cause quarrels by willing it again. Give it, transfer it, and don't deal with it again in your will. Usually, I also say when you do things in life, you deal with several issues that otherwise would arise in death. Things to do with disputing parentage, you can deal with them in life. Division, you can deal with it in life. Questioning your intention. Some people question how you can give your property to a particular person they despise. Say, how could our mother give our property to that one? They can't give you that decision. It's your decision. So some of the things you can communicate when you're still alive. You say, I've given. Yes, they did something for me. I've decided to arm them with property and I've transferred it to them. The only problem is that when you're growing older, you begin to become fearful of your children. You become fearful of them, that you cannot do certain things. You fear them. You can't say anything to them. They begin to question, how dare you leave that house to so and so? And some of you are shaking like this. How? This is your property. The Constitution of the Republic of Uganda has armed you. You have worked in the university for 40 years. You have retired. You have your property. The law allows you to deal with it in the manner that you desire. Give it to a friend. That friend helped you. You want, then your children say, but how dare you when you're shaking like this? So the last one there is it allows you then to explain your decisions to these people who are questioning. These people who believe that they should question you over your own property. The ones that you fear so much that you must explain to. When you explain to them, you say, well, this is my person. They helped me get into this job. They did so well. They helped me when I was sick. I believe I should leave a property to them. And it's my property. It's my property. I have decided to give it to them in my lifetime. If you contributed, please let me know that I can remove your share now and I give it back to you. Stop fearing your children. The last one is a company. A company is a business vehicle. As you go along, you create a business. I would strongly recommend do a business through a legal person called a company. And in this company, the beauty with it is that you can put all your children in it. All of them can have shares. All your family in this vehicle. And then you distribute shares. You put everything you own, your house, your land. Even you can write to MABS and say, now you get the form and you fill the form. And then you say, my entitlement, please, when I die, transfer it to the company. So in the company, we now deal with the thing as a company issue. When we want to take decisions, we sit in an AGM and then we take a decision. What do we want to do with our father's entitlement in MABS? We take the decision. What do we want to do with the business? It is good for business continuity. Those of you who are in business, because it is a legal person and it survives your death. It doesn't die with you. It continues. As long as everybody is there, you can deal with it. Liability is limited to the company. And you run the business on purely business ethos. So if you have a business, the recommended way can be, why don't you have a company? Tell your children, put them in the company, let them become shareholders, appoint them to the board of directors, let them sit and take decisions. And remember what I said in the first slides. Involve them, grow the business. Don't wait for death to approach you, then you begin teaching people things. Begin to teach the beneficiaries today, as you're going through life, as you're doing the business, teach them the ethos. So that when you die, when you retire, you can even retire and then you sit back and your children are on the board and they're taking decisions and they're distributing, everything is being done. But mostly what we do, we want to communicate when we are dead. We want to tell people what to do when you want to tell people what they should never do when you're dead. Why? You had 60 years with them. Why are you communicating when you're dead? Communicate when you're alive. Check them, and the company is one of the things. The beneficiary, from my experience, and the law doesn't limit who the beneficiaries are. The law does not say who should be. The law is quiet. But from experience, I'll tell you that the beneficiaries of everything that you're working for today is your spouse and your children. From experience, I think I've only come across one instance where someone was providing for other people. But from experience, your beneficiaries is your family. So if it is your family, your intention definitely is to provide for them. Set them up in life. Help them to start a business. Those ones who are leaving school, help them to start what in trusts we call advancement. You have children who have good business ideas. You help them, you advance them 30 million and say, let's see how it goes. So the beneficiaries are known. But also, as I've said, the law doesn't define them. You can define them in your will. You can define them in your trust. You can define them in your company. It is your property, ladies and gentlemen. You deal with it as you... But from practice, those are the beneficiary. I believe strongly that everything that we want to do, we should begin it early. When you have a child, grow them up knowing what the business ethos are. Teach them how to do business. Teach them the value of wealth. Teach them certain good instill. I think I saw in the opening remarks, it's not just material wealth. It's not a material legacy. It can also be good ethos, good manners, Character building. But you write a will of 30 pages, and then in the last 10 pages, you want to begin telling people you should not steal, you should respect elders. What have you been doing for the last 60 years? Pick them. So I believe that you should start all these things early in life. Don't wait for retirement, and then you begin to remember what you should do and what you should not do. But I say that again, be reasonable and be fair. Be reasonable and be fair. Regulate your anger. Forgive. And then move on. Some decisions that you think are controversial, you need to explain them. The law does not define who your beneficiary is, who your executor is, who your trustees are. The law does not require you to give explanations. But in society, I have seen that certain things need to be explained. I know that. You're doing something and it is out of the ordinary. You need to explain it. So, explain it when you're still alive. Explain your decisions, why in retirement you want to move from Kampala and go back to the village. Explain it, that people understand it. Update your wills. Update the information that we give to MABs. When they call on us, let's go and update the information. And when you think that you've not given the property to your spouse, your husband, your wife, your children, you're moving out of the norm that I have mentioned. You're giving your property to me, Bakayana the lawyer. People want to know, Bakayana yani, Yavawa. Where did they meet our father? But I'm the one in your will. I give all my property to Bakayana. And they begin hunting me down to kill me. In trusts, we have something called a secret trust. And that secret trust is an interesting thing. On the face of it, you appear like you have given me all your property. On the face of it. When someone looks at the document says, I give all my property to Bakayana, signed. But yet underlying it, you called me privately, you gave me another document, and then you explained certain things to me. You said, now, Isaac, you know I'm a very staunch Catholic. I go to Christ the King every morning, but I have 3 wives and 16 children. There's no way. So the secret trust, on the face of it, it says I've given when you actually have not. But you have something that you think that morally is difficult. So you then use that rule. But explain to your family that I've not given Bakayana. Bakayana knows what to do. And then they're all at ease. And don't appoint people they have never seen. Never seen me. It's the barrier, they begin seeing a person in a suit, a white shirt moving around with an envelope. They'll kidnap me and kill me. So you need to explain certain decisions. One, I believe that in doing all this, as we plan to retire, as we plan to die, at my last checking of the Uganda Law Society roster, we are approximately 4,600 plus minus lawyers in Uganda. Seek help. I always say that there are several professionals, they can help you to plan your retirement. Currently, we have so many people who can advise you on investment. So, starting with the chairperson is here. You have help. It's here in the university. Seek help. There are so many people outside there who are advising on how we should plan our retirement endlessly. How we should invest. Don't invest when you're 70. Please, 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 please. You have a lifetime. As you're working at the university, begin to try out businesses. You fail, you lose money, you get another one. You try, you lose money, you get another one. And then you get one where you farm up and you know this is the one, it begins to grow, you see it, you then hand it over. Your plan should be your choice. Yours, not mine, not his. Yours. Circumstances vary. So because the circumstances vary, you should then be able to make your own. The plan that suits you is a plan that you should make. If you haven't planned, as the adage goes, then you're planning to fail. If you fail, then I can assure you, for us the lawyers, we are waiting for you. We're going to take you to court. We eat your estate. Yes, when you come to me, I look at the estate, I say, I need 80 million. I begin to eat your estate. Your beneficiaries, count me in that beneficiary list because you did not plan. Therefore, I urge you, okay, the plan of retirement is now. The plan of death is now. Begin to plan today. Thank you very much for listening to me. Thank you.
Thank you very much, Mr. Isaac Bakayana. Can you give him another round of applause? I think that has been quite an informative session. Yes, we are going to have a Q&A section, so prepare those questions. For now, we're going to first have a demo on how you can nominate your beneficiaries using the MAPS portal. It will be very quick. It will be only about 10 minutes or even less. And then after that, we shall have the Q&A session. Yes, Ariho. We're going to have Ariho from Zamora taking us through the demo. And he's ready. Ariho, you can come through. Please share your screen.
Hi, Rebecca. Can you see my screen? Every room is occupied, man. Hey, Rebecca. Rebecca, you can see my screen? You can. Hi, Rebecca.
Hey, so now that's on. I think Ariho, you're now on the screen, and the team can be able to see what's on your end. As you can see there, the member has already logged in. So Ariho, you can take us through.
Yes, so first of all, thank you. Can you hear me? So thank you so much, Mr. Samuel Bakayana, the chairperson, MABS, and the trustees.
The physical team cannot hear you. Maybe I could try and do the explanation as you move the mouse. I'll be able to see it on my end.
Okay, that's fine.
So that's the MABS member portal. And at that point, someone has already logged in. As you can see on the portal, we have a section on my account. And under my account, you can be able to view the my profile. There's also a part of beneficiaries. There's also a part of consolidated funds, and there's submissions and withdrawals. So to nominate beneficiaries, you go to beneficiaries. You go to beneficiaries, and you can see there we have a section on guardian details and beneficiary details. So you can decide to update the guardian or to edit the beneficiary. So for now, Ariho has clicked edit guardian, and so you're able to add details of the guardian. As you can see there, you add the first name, you add the last name, and then the email, if they have an email or if they have another name. Then you add their current phone contact and their address, and then you submit. So once you're done submitting, you go to a section on adding beneficiaries. Okay, so under adding beneficiaries, you put the first name of the beneficiary you would like to add, then you add the last name of the beneficiary, the gender, the date of birth. You allocate a percentage of exactly how much that beneficiary should be able to get. And then you add the relationship. What relationship do they have with you as a member? Is it your child? Is it your son? Is it your daughter? Is it a spouse? There are quite a number of relations there. And then if they're above 18, you add the ID number, you add the email. If they have an email, you add the phone number, box number, and when you're done, you submit. So you can add as many beneficiaries as you want. So yes, I have been advised that you're on, so you can take over, please.
Can the members in the physical hear my voice?
Yes, we can hear you.
Oh, okay. Thank you so much, Rebecca, and the trustees and the previous presenter. Thank you so much. So as Rebecca has been taking us through, there are the similar steps. So I come to the dashboard. So when we are going to add the beneficiaries, like the previous presenter has taken us through, like it has to be, if at all we are planning for the future, we can do it right now. So currently, what as MABS, as we members of MABS, we have money we are saving with MABS, and at any certainty time, we have to plan for our money in case of any eventuality. So that's why we are nominating beneficiaries, those people that might take over or who might benefit from our savings in case of any uncertainty. So after you have logged in, you come to my account, then you go to beneficiaries. So we have a part of guardians and then beneficiaries. So guardians, these are people whom are under your care. So they can be those ones that are below the age of 18, minors. So you can first add them. Let's say guardians, you get any. Since they are minors, at times they don't have emails and phone numbers, you can submit, and then now we add beneficiaries. But if at all they are already above 18, you come and add beneficiary, you come directly to beneficiary details. So You first add them, you come to the details. If at all, so you add their names. For example, I'm using this one as a demo. So on the part of allocation, when it's always according to percentages, but it has to always add up to 100% because we are giving out all your benefits, all the members completely give them out. So that's why we make it to have to make sure that it's up to 100%. So in case you want to give it 1%, it can be 100%. If at all they are two, it depends on the percentage you want to allocate your benefits. So for example, you're doing a 50. This is, then you add their details and submit. Then, so that one will give them 50. So you have to get another person. So this person also, we are doing a 50 relationship. This is also a son. Add their details and submit. So we go to next. It's 50%. We have to get another beneficiary to make sure that it adds up 100%. So now, as you can see, the allocation is 100%. So we go to next. After that, one other requirement before you even log in, we always need a signature. And a signature, we always want it in an image format. So it's always advisable before you log in, you get your signature and write it on paper and take a picture. So when you reach on this part, you choose where you have saved your signature, let's say on your desktop or on your phone in images, then you attach it. Because when the administrator is reviewing your beneficiaries that you have submitted, we have to make sure that we see that signature that you have submitted as well. So after exporting the signature, importing it, we go to next. So now on this part, we always generate tokens. And these tokens are one of the security items that we use that generate for us a one-time password, which we have to also use and it goes to your email address, which you are registered with under MABS on your account. So now you click here to generate a token. So they tell you that a token has been sent to your email. So you copy the token that has been sent. And you input it here and then submit. So after submitting, your details for the beneficiaries are now submitted to the authorizer and the secretariat, such that it can be reviewed and then it will be approved. Once they're approved, you'll be able to see them on your account. That is it for, those are the steps for nominating beneficiaries under MABS. Thank you so much.
Okay, thank you very much, Areho. I hope that we've now familiarized ourselves with that. We shall be able to go and try it out. And so we are now going to kick off the Q&A session. We're going to start the question and answer session from the session we had with our facilitator, Mr. Isaac Bakayana. So if you don't mind, I'll read off some of the questions that we already have here, and then I'll take a few questions from our physical team. There's a question from Anne Apol online who has asked that what is the difference between a foundation and a trust? Which one of these is better for purposes of providing for beneficiaries and or preserve and grow wealth? Then another question is, many married women don't take wills, leaving the husbands to do it on their behalf. What is your advice? I think that's it for now. No, one last question. If in my will I name all my children, but state clearly that I will not give some named children with reason, is it not allowed if that's my written wish?
Thank you. There's a second one I didn't get about married women. If I can have it again, please.
The one about married women?
Yes, please.
Okay. Many married women don't make wills, leaving the husbands to do it on their behalf. What is your advice?
Thank you very much. I'll start with this one. It is important that you have your own will. The will is for you to decide what you want to be done for you. It is your wish, it is your will to write what you desire to be done with your property, to be done when you die, to be done in respect of distribution. So when the husband writes the will, he's writing his own will, not your will. So it is not the wife's will, it is the husband's will in respect of the wife. So the advice would be, because this is your own document, because this is your own property, it is better for you to make the will. Now, having said that, you can also will it that your husband does your will for you. I don't think there's any problem. Well, your husband now deals on behalf of your property, but on the whole, I would think that the proper thing to do would be for every person to have a will. I have seen instances where people have joint wills. A husband and wife write one will. I've also seen that happen, and it does not present any problems. In my will, if I name all my children and don't give some, I think the premise, the entry point is the property is your property. And the law allows you to deal with your property as you wish. So you can name all the children and only give the ones that you want give. The law has no problem with you. But I've said that from practice, I have seen that generating a lot of quarrels. To make the point, you have to go to a court of law when other people are challenging that will. That is the problem with it. But on a principle, on a pure principle of law, you can actually have your property and give it to one person because it's your property. You deal with it as you want to do. What's the difference between a trust and a foundation? They are related, but probably not the same thing. People who want to do, I've seen people who want to do charity. You want to educate children, you want to take care of people's health, you want to help, you do a foundation. Usually you set it up in the form of a trust. So what we call a charity, you want to do something nice, so you set up a charity. A trust, on the other hand, a foundation can be created as a trust. That is okay. A trust, on the other, I don't want to call it on the other hand because they are similar. A trust, on the other hand, it can take so many forms. One of the ways it can take is a charity, a foundation. But also we're allowed to make our own private trusts over my own property. I can have a trust over my MAB's money. I can create a trust over it. I can create a trust over that money, but make it part of a foundation so that I can help people who live in Katanga. I create as a foundation. I can have, there are so many different types. So the foundation can be created by way of a trust. A trust can also do so many other things other than a foundation. Thank you very much.
Thank you very much. Do we have any questions in the room?
I'm called Vincent Abigaba. I'm a principal registrar. First of all, thank you very much, Mr. Bakayana, for the information shared. I have about 2 or 3 questions. The first question is about what you said. You talked about the executor. Executor, I didn't properly understand. Like you said, the role of the executor is to distribute property. But in this case, we have got another title that is related to that, of an administrator. Who is an administrator in this case, and how is this administrator related to the executor? And then also the administrator, what are the roles of the administrator? For example, and the administrator is the administrator mandated, first of all, to distribute property like land, or can he or she sell off property either on his or her own behalf or on behalf of the beneficiaries? And then lastly, if it is a family property, but in this family property, both spouses have property that they have owned on their own. For example, if the husband, and as the head of the family, is distributing property or making a will, does he or she leave out the property that is personally owned by the other spouse, or the head of the family who during this distribution puts everything in the will? Thank you.
Thank you very much, Mr. Abigaba. I'm seeing another question there.
Yes, please. Thank you very much, presenter. A lot has been picked. I just wanted to add something about the executor and inquire slightly more whether the executor can be one of the beneficiaries, executor or administrator. I think majorly here we looked at the executor. Can that be one of the beneficiaries? Then 2, if I have given my son a piece of land and transferred, would that be a life gift? And if I failed to indicate anything else for that person and said, I already given that, would that cause more trouble? it could be a gift of life, and I have that sorted. Thank you.
Thank you very much. I did not get your name, please.
Esweri Wandera, lecturer in science.
Okay,
Honors.
thank you very much. Do we have another question?
Thank you very much. A lot has been learned, but I have a few questions here. My first question is, what happens if I entrust my will with a lawyer and she dies before I die? Another question is, can I still be in charge of the property I have distributed, especially to my children? Another question is it wise, or can MABS be in charge of a copy of my will so that it can help me after my death? Another question is that as a woman, if I have acquired property, is it allowed for me to share it without giving my spouse? Won't it be like attested or maybe complained about? Those are my questions. Thank you.
Okay, I think we can answer those for now.
Thank you very much. The role of the executor. The role of the executor is to execute the will, to put in place the will. So their role essentially is to, one, go to court, apply for what we call probate. Having gotten the probate, move the property into their name first, because dead people don't transfer property. Then, having transferred it into their name, then distribute the estate. That is the role of an executor, period. Nothing more. That's why the law has now been amended 2022 recently, that they have given executors 6 months within which to close an estate, because your role is to just give the respective beneficiaries and then you're done. Then who is an administrator? I'm very glad that this has been brought up, because I didn't talk about it. When people die without wills, and I really encourage you not to die without a will. Please, having listened to me, if you don't have a will, write one paper at least, sign it, get 2 witnesses. When you die without a will, the process is long and painful. Because, one, you have heard of the Office of the Administrator General. It's a public office. You go there. They tell you, first go to the LC1, first have a family meeting. You have a family meeting. In the family meeting, you appoint the people whom you want to be administrators. When you agree on them, they tell you, now take them to the LC, go to, I think they say LC3 or LC5, one of the two. You go there. Then after that, you come back to the Office of Administrator General. Then they give you a certificate of no objection. Then now you go to court and apply for the authorization of court. This is what we popularly know as letters of administration. Whenever you hear letters of administration, the person died without a will. Because if they died with a will, what we know is called a probate. We call it a grant of probate. What is the difference between the two? The obvious one is, in one, there's a will. In the other one, there's no will. There's another scenario for administrators where you have a will, but you didn't appoint administrators. So you write a will, but you don't appoint executors. You leave it out. You forget it. Then you're going to get administrators. What is the role of an administrator? It's the same as an executor, to also distribute that property. Ladies and gentlemen, An administrator, an executor is not the owner of the property. Is not, I repeat, the owner of the property. His role is a manager to distribute, and that is it. What if we have a family property which we own jointly with my wife, and then I also have my own property? The principle in the Constitution is that the law allows you to own property either individually or jointly. The law allows you. People think that it's only spouses. No. It can be brothers, it can be sisters, it can be friends. And we can buy this whole building together, and we have 30 joint owners of this building. Now, if we are joint owners, when we are buying it, we can agree on the shares that we're going to have each one of us in this building 5%. Your ownership in this building is 5%. That 5% is the one that you put in your will. The 95% you leave to the other owners. If you own a property with your wife, in law there are two possibilities. You can own it jointly. And we usually say, if one of you dies, then the property by law becomes the property of the surviving spouse. That is one scenario. The second scenario is where we still own it jointly, but all of us have shares which are defined. And even as a husband and wife, you can do that. You agree that we have bought 10 acres of land, but you, my wife, you will own 5. You even demarcate it. You say 5 is here. That is yours. Me, husband, this is my 5 acres. It is here. Your entitlement is the 5. The title is Bakayana and wife. But we have agreed between me and you that the 5 is yours and the 5 is mine. So in the will, the principle is in the will, deal with property that is yours. You can own it jointly, but in that jointness, you can say, I own 5. That is the 5 that you deal with your will. Mr. Wandera, executor can be one of the law has discouraged it because you have a conflict. Imagine I'm a beneficiary. I'm supposed to benefit from this building, but I'm also supposed to oversee the implementation of that distribution. So I have a conflict of interest. My interest conflicts with my duty. So the law has discouraged that kind of scenario. It's discouraged generally because your job is going to put you in conflict with your benefit, and the law doesn't encourage that. So it's discouraged. If I transfer land in my life and I exclude the benefit, yes, you're allowed. It is your property. You can deal with it in life. You can deal with it by will. If you give someone property in life, you can go ahead in the will and say, you, Bakayana, I gave you in your life. You have no further entitlement in my property thereafter. And I encourage parents also to talk to these people when you're giving them. You sit them down and say, I'm giving you in life, and that's it. So in my will, please don't come expecting anything. I've seen as a lawyer, parents of these days, you fear your children like dictators in your lives. What is the problem? You sit them down and say, I'm giving you a bicycle, sir. Say, I don't want a bicycle. How much did you contribute? Nothing. Get a bike. So when you give in life, the law does not say you cannot give in death. It doesn't say that. Because the principle, again, is you're the owner of the property, deal with it in the manner that you want. Yeah? So it means you can give in life and then don't give in death. It's okay. You can give in life and also give in death. The law allows you because it's your property. You deal with it in the manner that you want. What happens if I entrust my will with a lawyer and they die? Usually, the death of your lawyer does not invalidate your will. Your will is still very valid. The only problem is, can I get my will after the death of my lawyer? That's the only problem. So, Most of us lawyers are advised to, when we are keeping documents, you mark the documents, you put the name of the owner, you put their number, such that the documents can be managed in your death, either by the partners who survive your death, or the law council, which governs us, will come into an office if it has been a sole proprietorship. They can come in, open, look at the documents, then begin calling you up. So the death of the person who has been keeping your will does not invalidate your will. The only problem is, can I get that will after? I usually encourage that if you have a will, don't keep it with only one person. Keep it with a lawyer. Make 3 copies, one with your lawyer, one with your friend, one with somebody else, that you can have places where you can get it from. Can MABs be in charge of my property? I don't know whether their mandate allows them. The law does not prescribe where wills should be kept. The law that governs wills does not say where the will should be kept. It can be kept anywhere. So you make the choice. Where do I want to keep my will? If you go to MABs and the MABs accepts, well and good, there's no problem. We can keep it. If you want to go to a lawyer, no problem. If you have a brother, a sister, and a bank, I don't know whether they used to offer, but I don't know whether they do it anymore. A bank, you go and keep your will there. But importantly, your will must be kept with a person who will be able to produce it when required, produce it. Because we've seen instances where people die, we all know they had a will, but no one knows where it is. We are all sure he made a will. He talked about it often. He talked about it often. He always mentioned, I have a will. But ladies and gentlemen, no one knows where you kept the will. If we can't find the will, in law we shall assume you died without a will. Then we shall go back to the scenario of Mr. Bigava, where we assume, we take you through the other process I've talked about, going to LC1, going to Administrator General. It's a longer, more painful process. When you die with a will, you don't need to go to Office of Administrator General. You don't need to go to LC1. You don't need to go to anybody. You just go to the family division of the High Court. You file your papers. There's a process we call identification. Identification, they call the beneficiaries. They call the executors. They come with national IDs. They come with LC letters to just confirm identity. Because there's much fraud in this country. Maximum fraud. When people come to court, we need to confirm that these are the ones. So you come with a original national ID. I have had people who are not registering for national IDs. You can't, because that is how we prove. Original national ID, read the LC1 letters, and the individuals. That's why I said when I was presenting there that try to appoint people who have time, because that process is also a bit disturbing. So people must be able to devote time, sit there, wait, etc., etc. So I think those are the questions. Oh, sorry.
Sure.
Can MABs have answered that one? As a woman, if I acquire property, can I share it with my spouse? Yes, it's your property. Absolutely. If you buy, sorry? Can you exclude your husband? Can you exclude your husband? Yes. Yes. It is, ladies and gentlemen, I wish I had moved with my constitution here. The constitution says you have a right to own property. And listen to the words that follow after that. Individually or in association with other people. And to deal with it in the manner that you desire. It is your property. So as long as what you're doing is not unlawful, you're not training people to take over government. There is those ones. But as long as you have gotten your land, you bought it, it is your property. You can wake up in the morning and give it to the church. I give it to charity. Donate it. Give your husband. Exclude your husband. All legal. The quarrels that we have in society are beginning to look at you badly. So that is the banter. It's not legal. It is your property in the same way that a man can go and buy his property and deal with it in the manner that they desire. The law will now women are all equal under law. What a man can do under the law, a woman no. You can acquire your property, give it to your children, exclude. It's okay. Give it to church. Oh, yes. Perfect. There's no problem. As long as it is your property, you deal with it in the manner that you desire. Thank you very much.
Thank you very much, Mr. Bakayana. Talk about joint property, e.g. land, and there is no will. What happens in case of death? What about the money in banks? Can it be protected by the will, or only next of kin registered with the bank can access that money? If all property is jointly owned with spouse, is there a critical need for a will? Accessing money and other properties after death is so tedious, and sometimes people fail to access this property. What can we do to ease this process? And then the final question, can the family home be willed to one or a few of the beneficiaries? Can property owned by the couple jointly be willed, i.e. the shares of one, can they be willed? Or does that property become automatically owned by the remaining spouse? Oh, there's another one. Can I send a will online since I'm abroad without people witnessing signing? There's a last one. Case where a will says children use the estate together, but beneficiaries do not agree. What can an executor do? In cases where the will says children use the estate together, but beneficiaries do not agree, what can an executor do? Yes, you can answer the questions.
I call this the last one, entitlement syndrome, where people believe that they're entitled to make a decision in respect of their parents' property. The person who owns the property dictates how that property is used. And the person who has the property has said it is going to be used jointly. And the children don't agree. The property owner has given the directions. So that's what should be done. But in practice, I will tell you that if they agree, they can sit down and say, thank you very much, mommy. Thank you very much, daddy. You want us to own jointly, but we're going to sell it and distribute the money. If they agree, well and good, because it's ultimately their property, ultimately. Now, for if you say all of them on principles, on pure principles of law, they must do what the will says, on pure principles. But I know that in practice, when they sit in a meeting and they say, we want to sell this building, and they all agree, because the transfers are going to have their hands, and the transfers don't ask questions. What did the will say? If they all sign, well and good. So in practice, I know that actually they can do what they want to do. But if we enter a court of law, they will have difficulties doing what doing something that is contrary to the will. Can I send a will from outside Uganda without signing it? No. A will has ingredients, things that a will is a very important document that it has to be authenticated.
A will must be authenticated by your signature. The signature is like a signature on a contract. When you sign on the contract, you have agreed. When you don't authenticate a will, it's a forgery. We don't know it. We shall deny it. When you go to a court of law, we shall say there's no will. So a will must be signed. A will must be attested. And attestation is people who see you signing, because those people are important to prove your will. So it's not just making a will. Some people make wills and then they say, neighbor, are you there? I'm sending a document in an envelope. You sign for me and you return. And they take it. That's not attestation. Someone must be able to ask me, did you see her sign? That's a question. And I say, yes. Is that her signature, the one you remember? And I say, yes. You confirm that this is their will. And I say, yes, the will has been proved. But sending a will by email, that's not allowed. Can a family home be willed? No. We have two scenarios recently. The High Court and also the Parliament has amended the law, where now homes which are occupied by spouses, then one of the spouses dies and then he wills it to somebody. It's no longer allowed. It cannot be allowed. We call it a residential holding, a place where the spouses have ordinarily been living before the death of one of them, can no longer be willed. Especially, you can will it to the one who is inside, the wife or the husband. But you can't say, Bakayana, the heir, please come and take over. It's not allowed anymore. So it can no longer be done. It used to be, people had been doing it for a long time until recently when the High Court said, no, stop it. Then Parliament followed shortly thereafter and legislated and explicitly said you can't do what people have been doing before. Accessing property after death is tedious. I think I must emphasize that you need to plan your estate today. Why are you making all this wealth and hiding it from the beneficiaries of that wealth? You buy land, you buy estates, you buy shares, you buy stocks, then you put them under the bed, you hide in your friends. Where are you working for? Whom are you going to give them to? The people you're going to give them to, let them know. In fact, that they don't have to struggle to find out where these properties are. Because ultimately, when you die and you've died with a will, it's simple. I know this as a practitioner. It's very simple. Get the will, go to the family division, go as the beneficiaries, the executors, the surviving spouse, go to they identify you. What's your name? ID, rate of the LC. What's your name? ID, they tick, and if you go before a judge, 30 minutes, you're done. 10 minutes, and you then transfer the property to the executor's name, and there's no stamp duty payable now. You pay registration fees, 15,000, 20,000, etc. Then the executor transfers into the names of the beneficiary and hands over. I mentioned at the beginning of my presentation, don't appoint people you don't trust. Please, don't appoint people whose judgment you don't trust, whose motives you suspect. They are dealing with your lifetime wages. You don't trust, don't appoint. Don't. Because these people, ultimately, the property is going to go into their names at a certain point. Those are the estates you find have been administered since 2008. And you're asking someone, how have you been administering an estate since 2008? If you own joint property, yes, there's no need for a will, because one of the principles in law, if we own jointly, if one of us dies, the survivor by law takes everything. So if you're spouses and you don't want to write a will, you can have, you own this building jointly, you own the land jointly. When one of you dies by operation of law, the other one is the owner. So in that instance, you may say, we don't need a will. Yeah, you may not need a will. Money in the banks. Money in the banks is part of your property. Anything that is property, whether it is land, whether it is a car, whether they are shares, whether money held by MABs, anything that is your property can be willed. anything, including money in banks. The day that a bank learns that you have died, they flag their account and there's no more transactions on their account until you bring letters of administration or a grant of probate. And they put for you what they call an estate account in banks. The moment they learn that you have died, immediately they flag the account. It's no longer accessible because now they require authority. This person who is coming to draw the deceased money, do they have authority? Do they have authority? And the bank doesn't know. The bank is a financial institution, doesn't deal in death, deals in money. And its duty when you put your money there is to secure it. So the day you die, they freeze the account, then you must come with authorization of a court of law allowing you to open that account and remove the money. So it is protected. What I usually see, and I think I've also talked about this in respect of MABs, is that in the bank, you'll go and put there one form saying that if I die, give my money to X. In your will, you go and put other things there. When you're having dinner with your parent, with your children, you also tell them other things. Now, you're the one causing problems. Be consistent. If you go to MABs, the member beneficial form must be consistent with what is in your will. What is in your will, if you desire to talk to your children and tell them what is in your will, then also be consistent. Like that you don't cause friction within the beneficiaries. If all my property is owned by my spouse, do I need a will? You have nothing. But a will, as I've said, does not only talk about property. There are people who are, you're Catholic, you're married to a Muslim. You want to be married, to be buried as a Muslim. There are things you write in your will. You've been married for 40 years, you don't want to be buried at your husband's place. You want to be buried where your father was buried. The things you put in the will. In your will, you want to give her your clothing, your shoes. You want to. So a will is not just about property. It is a will. It is your wishes, your will. So you write anything you want. I want to be prayed. When I die, please take me to All Saints Cathedral. You write in the will. Please don't bury me after 2. So don't give speeches. Write in the will. Because again, the law does not prescribe what you put in a will. It is your will. Write what you will. Thank you very much.
Thank you very much. And we shall have the final set of questions. I'll first take the ones that are physical. Do you still have any questions? There's still one more from Innocent. There's a question there. Yes, you can.
Yeah, I have again more 2 questions. One is still about the will. Yeah, for example, would there be a need for a will, rather an executor, when there is a will and the will is indicating the heir? And also, what is the role of the heir in this case? And the heir work as the executor? And what about the next of kin? How is the next of kin related to being a heir or an executor? Thank you.
Thank you very much. Innocent? Yes, please.
I'm not sure whether I'm late for this kind of thing. The structure of an ideal will, how it will look like. Yes, you have said about the property should be included. Does it need a lawyer? Does it need neighbors? What are the ideal structure of a will?
Thank you very much. Okay, I'll take the online questions. If the house is given to the surviving legal wife and she has children, but there are also other children of other wives, is this wife allowed to will it to her children and not the other? Is the surviving wife allowed to will it to her children only? Yes, that's it.
The quarrels that take us to court are quite many. And because when the people make the law, they don't predict everything that can happen in society. They give a structure, and then what happens that the scenario arrives where someone gives the property to the surviving wife, the surviving spouse, I'm sorry. And then the surviving spouse gives it to only her children. One example I have come across before I answer the question is someone who gave all his property to his wife. And he said, enjoy your property in your life. And then he said, after you die, then the following children will take. Then he started giving the children. And the wife survived until about 90. The wife was not dying. The children started saying, can we sue the wife? But because we're not getting the property, she's taking so long to die. But so the entry point is, if it is your property, the moment that I give my property to my spouse, it ceases to be my property on my death. And then it becomes my wife's property. It's her property. Property is not just property that we make by working at Makerere. I can be given property. That is also my property. So the day that that property becomes my property, by virtue of which it's my property, I can give it to my children only. Because it's now part of my property. It has been given to me. The fact that you've just gotten property by a gift does not make it any lesser of your property. It is as much your property as the property that you have worked very hard for. So you can actually give it to only your children. But the quarrels that you're going to generate are quite many. The structure of the will, of an ideal will. Usually people, the ones that commonly, your name, date of birth, your spouse, your children, your property, and the distribution. Ideal, the things that are so critical. Who are you? Who is your spouse? Who is your spouse? Name the spouse. Who are your children? Name them. And I've said, even those ones who are outside your home are your children. As long as you know they're your children, they are your children. Name them. And then the property and its distribution. Ideally, that is an ideal structure. The other things, where to be buried, when to be buried, who shouldn't come near me, that is, you can put, but whom do you hate? Not necessary, but it's your will, not what you want to put. The law does not give a specific structure. The law doesn't say this is how a will, the validity of a will is, have you signed it? Is it witnessed? It's a will in law. The other things add how you want to add, but the ideal structure is that one. Do I need an executor if I have an heir? They're not the same thing. An executor gives effect to the will. Yeah? An executor gives effect to they execute the will. They distribute the property. Heir is the person you want to stand in your shoes when you die. Yeah? And it doesn't need to be an executor. The heir is basically the one you have left in your chair. I think the Succession Act calls him a customary heir. Because in our customs, we've taken the view that when you die, you must leave someone in your... So they're not the same person. The role of the executor is to put your wishes into force. An executor is someone who has come into your shoes. You need them both. An executor, I would say you need. An executor you need, because an executor is the one who is going to transfer property, who is going to put your wishes into place. It is a will without an executor is going to land you into the other process I talked about. An heir, I don't know. Okay. A next of kin. A next of kin is also not. A next of kin is someone, if there is an emergency, if there's a problem, if there's something, and you can't talk anymore, you can't write anymore, who is that next person that you want? So, executor is putting into force. And next of kin is, if I collapse at Makerere, who can be contacted? Yet in law, we want an executor. Your next of kin can also be an executor, because your wife, usually all of us will put our spouses. Next of kin, my husband, my wife. Yeah. So, but I've also warned you earlier that it's dangerous to make an executor, a beneficiary, an executor. So we exclude. They can do the job, but the law doesn't encourage it because of possible conflict of interest. The last question I've just been shown is, because of technology, can I have a video recording? Ladies and gentlemen, the law has not advanced that fast. The law, the Succession Act is quite old, but I have seen a couple of people who are bringing video recordings to courts. But for us, the lawyers, we shall argue that if Parliament wanted to change the law, they should do so and tell us, I can sit before a video and I'm recorded, because people are recording videos. I've seen them a couple of times in the family division. But for us lawyers, when we go there, the law insists that a will is in writing, it is authenticated, and it is attested. The law, even when they amended the law recently in 2022, they did like that provision. So the technology has gone far ahead. The law is not growing at that same speed. We still require you to authenticate the will by the use of your signature and then the witnesses. I think those are the questions. Okay.
Wow. Thank you very much, Mr. Bakayana. Let's give him a round of applause. I think we've had quite an insightful session. We've learned a lot. We've learned what to include in a will. I think I'm also going to start right now, even though the years are not yet there, but I'll start. I'll work on it. So I'm hoping that we shall put into practice the knowledge we receive from these sensitization sessions. So you'll allow me to welcome our chairperson, Board of Trustees, to give our closing remarks, and then we shall be done for the day. We shall also have a group photo. Please do not leave. We shall have a group photo after the session. We welcome you, our chairperson, Board of Trustees.
Right. Thank you very much, Becky. And thank you, Mr. Bakayana, for that insightful presentation. Yeah, so I think a lot has been said. And I think where he started from, one thing was clear, that death is inevitable. Okufa weekuli, ne bw'okola otya. Azaalibwa, amala n'akola ki? N'afa. So we need to prepare for that. And then, of course, he talked about the issue of tax planning, which we normally fear. We don't want to pay taxes. But lately I've heard, when IFRIS came, there's a lot of friction there, but some people are now happy with IFRIS. Even if they are not at their premises, they are sure they'll see this sale has come in. This sale has come through and so on. So as we will as well, it helps us also with the tax planning, like he said. That's something good we need to talk about. Then there's an issue that has been some kind of, like they say, stone in the shoe at MABS about the nominees. So he's actually encouraged us to nominate people. So when you're called upon, kindly do come and update your nominees, or even before you're called upon, please go and do that so that in case of anything, everything works fast. Sometimes there are complaints, people have taken long to be paid, but they're still doing due diligence. But if you did it earlier, that would sort everything. So we encourage you to do that. Then the other issue was, character building in our children. I think that's very important. So you don't do it in your will, like he said, because then that becomes a problem. Then finally, I would like to talk about the demo that was done. We're sorry we could not do it in another language, especially for those who do not speak it well in English. But if you really need help, please reach out to the Secretariat, or you can reach out to an ambassador in your department, in your college, and they can take you through. So if they can't, still reach out to the scheme office who can be able to help you. So I'd like to thank Mr. Bakayana once again, and thank you all who made it here physically. And for those of you who are online, really appreciate your time. And we look forward to seeing more people coming physically in the next member sensitization meetings. And of course, Isaac has done a great job. I pray that we put these things into action. There's that myth that when you do a will, you die, but I think many have done wills. You just gave an example of someone who has stayed up to 90, So we can still survive, but for the good of those who stay behind and for smooth kind of, after you've gone, a will is important, like you emphasized. So I want to thank you all and wish you a nice evening and see you again next time.
Thank you very much, our chairperson. I think I cannot add any more words after those ones. So I welcome you all to the podium so that we take a nice photo. We've had an insightful session and want to keep memory of this session. So thank you for coming. Thank you for attending. Yes, you're welcome here. You can all look here. I'm just translating what he's saying. Smile. Yes, you look good. Thank you very much. We wish you a very blessed and happy Easter. Thank you very much for coming. We know some of you are traveling. Safe journey masses. Have a blessed Easter. Yes.